Good morning. We're going to start a little bit late this morning because of the internal operations of the Parliament have caused this delay, basically, and a few problems in the town as well with traffic. So, from a practical point of view, the interpreting in French Number 3. Okay, English 2. We're going to have passive Spanish, 3 for French, 2 for English, and a few pieces of information. First of all, after the meeting, which is a reflection, there'll be a little review afterwards. So, I'm a French MEP from the southeast region, from the Socialist Democrat Group. I'm delighted to welcome you. I'd like to thank FEANTSA and Housing Rights Watch for this initiative, especially those who've worked very hard on setting up the programme. Emma Jones has already left for other things. Now, to introduce the morning session, which is going to be very intense, just a few words to start off. There's a reason for this conference in the sense there are activities going on. I have a sort of a parallel electoral life, if you like, in Lyon, and involved a lot with the people involved with homeless people on a local level, and this interests me in terms of my parliamentary mandate. I think we can share during the morning a series of findings. The first one would be it's a bit of the icing on the cake, if you like. We need to mention it first of all. There's a crisis that is lasting. This is very difficult, and it's very difficult to bear for many of our citizens, young people, women, migrants and families who are out on the street because they have no other choice. Unfortunately, you can imagine the situation will carry on for some time to come, but it'll be too long, however long it lasts. You should know that, for example, that our NGO, Oxfam, has published a report with a very alarming scenario, saying that Europe could have 25 extra poor people from now to 2025. So that should lead us to reflect hard. It's a big concern. For our citizens who are affected by this situation, they suffer some really dramatic consequences, which are there. In the findings, I imagine that if I read the list of people who are going to speak today, the austerity measures which have been taken in Europe have been imposed on a certain number of states. Public policies have difficulty in adapting to this change, and these austerity measures obviously have a major impact on poverty and vulnerability. Taken all together, with a growing context of populism, with the adoption of measures, strong measures, which I would call shock measures, either locally or nationally, which set out to give an impression of security to populations, but they're really it's a process of criminalization of homeless people or persons in difficulty. So we need to react. We need to do something about this, because you will, during this meeting, you're going to express your views in the meeting. I would also like to add, as an introduction, some elements that will be discussed. The fact this phenomenon of criminalization of homeless people could have a very visible effect it could be a very visible measure, but also it could also take the form of a more hidden or insidious type of approach. For example, when like you've got municipal decrees, or you've got an example at municipal level in France, which are not necessarily applied, but can be applied. They constitute an extra threat. They're like sort of a sword of Damocles, which are hanging all of these already vulnerable people. So, even if I say it in general terms, there's other phenomena. There's a dilution of responsibilities, if you like, with certain people who are discriminated against and are not allowed to access the social services or social housing or shelters, and they're in a very, very vulnerable situation. But their situation is worsened because they're in that situation. So it's a paradox. And that's, for example, there's also financing to reduce poverty applied, but they're sort of ruled out, they're sort of cancelled by other sort of measures, financial measures that don't favour these people, which mean that we have to react against it. You know, the European Union has a certain amount of power, but in certain contexts it's limited. But this doesn't, within the Parliament, it doesn't prevent us from at least becoming aware about the situation and to oppose the renationalisation of social issues, has been in the case, especially of food aid, for example. There was a programme to the more needy people. There are initiatives that don't want the European Union to act on this front anymore, and they want to do it at national level. But the EU should continue this role of and to alert people as well of these situations and of these criminalization initiatives. So we need to go into depth on a number of tracks, if you like, or there's going to be, and surely there's going to be an exchange of views on to see who's doing what, and if we can compare and share things, and also across-the-board approaches to see how can we share our concerns and create a culture, an inverted commas, of integration, and that is seen through facts. And obviously, we all need to contribute to put an end to these practices, which create a very fertile terrain for populist politicians and but we need to that sort of initiatives can deconstruct social cohesion. So these are very important things. They're essential as far as I'm concerned, which and they're expressed through, I'm sure, the things you're going to say, that you're going to, the information you're going to give us now. And I'm going to finish there, but I have to leave, unfortunately, to go and vote on a certain number of dossiers in the Commission on which I'm working on. So please, I apologize for leaving, but it's not that I don't want to be here, but I have to leave. And I'd like to thank you once again for having organized this conference. I haven't looked at the program too much in detail, but I'm sure that it's the chance to we'll find as we go along. But I'd like to hand over, first of all, to the name of Housing Rights Watch, Guillaume Fernandez, on the issues of this European report on the criminalization of homeless people. Thank you very much. Good morning, everybody, and especially to thank you for inviting us to take part in this session on homelessness. It's important to bear in mind that the report that we're presenting today that comes out the indignation of entities of FEANTSA. I think the French is now coming through. I don't know. Non, c'est pas. Français. Ah. Okay. English? Can you hear English? Good.
Là?
Hello? So after that slight technical glitch, just to say thank you for the invitation and participation in this seminar on homelessness, because the report that we're going to present today is born from indignation of members of FEANTSA and Housing Rights Watch and Hope, for example. We've seen that many homeless people, when they're out there on the street, are fined, receive sanctions, they're arrested and even expelled from a particular area of a city into another, or sent outside a city, or of one country to another. But this report is also born of the fact that we're convinced that homelessness can be eradicated. Not just a question of managing it. And the human rights approach can help us to guide public policies in this regard. So, my intention would be to explain the theoretical framework in which we've participated in, and we've concluded with collaborations with Housing Rights Watch, and to say that homelessness is the maximum expression of a systematic violation of human rights in our societies. And it shows the interdependence between social, cultural and economic rights and political and civil rights. This essential interdependence shows us how homelessness is a process of systematic violations in different states that lead a person to be out on the street. Traditionally, from the field of sociology, the reasons that led a person to become homeless were debated between personal reasons, health reasons, drug addictions, for example, alcoholism, and other causes on more structural reason, market trends in housing, the levels of occupation of housing, and for a few years now, the European Observatory of FEANTSA went beyond this discussion as an analysed homelessness from the paradigm of social exclusion. So, understanding that homelessness is a continuum of situation of exclusion from decent housing. So there are many reasons, and apart from the personal and structural ones, they have to do with support networks that people might have, their families, their communities, and also institutional reasons. The lack of adaptation of public services when it comes to intervening with homeless people. this paradigm of social exclusion and these definitions of homelessness have been adapted at the highest level of European political bodies in this Parliament through written declarations. I highlight this because in the field of penal law, of criminal law, the process has been done in reverse. The corrective model of the 70s, which was based on prevention of the offence and the rehabilitation of the offender, in the 80s this was gradually disappeared because of the neoliberal and economics-based thinking, and which made the delinquent a rational person, amoral, who decides to commit an offence by analysing its costs and benefits. So the prevention solution in terms of preventing the crime or the offence means higher and higher fines. Structural causes disappear, and the individual is held responsible for his or her acts. In the 90s, under the risk, the theories of society of risk, and there's no longer do we think in terms of guilt, but the risk of committing an offence. So the offence is not pursued, but belonging to a particular social group, which can be considered risky. So the poor people and the people who are out on the streets are considered dangerous classes that generate risks, that create risks. So when cities are more and more showcases for consumerism, and areas where we structure the expansion of private profit, people in a situation of poverty, as a result, they are considered a dangerous social class. And to manage these behaviours, the sanctions in civil law and administrative law have been faster and more efficient than in the penal code when dealing with these sort of problems. So, from what we know, the criminology of intolerance, different policies have been developed: broken windows, zero tolerance, which are basically, these are policies. The first ones are based on the offence is greater in those areas which are not well attended in the cities. Zero tolerance, I'm going to summarise it very quickly, wants to penalise not the people in themselves, but the actions that those people commit. It doesn't. There's no consideration given to the reason why they're committed. If they carry out a certain action and cross the certain red line. And the last one is people who are repeating offences. It's considered that they should receive a higher sentence if they've, for example, been detained 3 times. Now, the risk is never objective. It's a concept that's socially and culturally constructed. So the media have a very important role in the creation of public opinion. And so politicians know this, and they're very, very well aware of it. Quite often, to show security and the fact that they're in control in the face of risky situations or groups that are considered to be risky, politicians make speeches that criminalise and stigmatise these populations and groups. They create laws and regulations which in many cases are unsuitable and especially cannot be applied. Because at the end of the day, the most important thing is not the offence in itself, it's the message that has been transmitted to society. So this is called a symbolic penal code, and it has to do with the resurgence of a certain culture in which the reforms of penal codes are justified, and the idea is to fine people who are always out on the street, It doesn't matter whether they can pay the fines or not. It doesn't matter that we don't have any information about whether they're residents, so they don't have a fixed residence. So, as I say, politicians are emitting this sort of image of security and control. Now, these trends, together with with the culture of exceptionality, there's another phenomenon there. We could say that this is a question of punishing everybody on the same basis, but there's always one particular group or one lot of people who are more aggressive than others, so exceptionally, we can justify exceptional measures against them. With this culture of exceptionality and what I've explained now, there's a new syndrome here, which is the penal code of the enemy. It's a concept that is basically the construction of the other, in inverted commas, i.e. the other who is not like us. We have an identity, and those people are outside that identity. They justify exceptional measures for people who don't adapt to socially accepted behaviour. They are not under the rule of law. In a sense, they're just subject to state regulation. They don't have rights themselves. So when we apply this penal law of the enemy, this is characterized by bringing punishments forward in the event of a possible offence, totally disproportionate sentences, and relativizing any guarantees for trials, for legal procedures. Nowadays, in Europe, we can see it with immigrants. In many cases, in many countries, they're being subjected to spot checks in the street, where they are shut away in detention centres for immigrants without having committed any type of offence for 60 days, for example. There are cases which that figure is higher. And in many cases, the situation in those centres is deplorable. And it doesn't comply with or fulfill the basic standards of living. In Europe, there is evidence that the objective of these regulations for anti-begging ones, for example, it's not just homeless people. They've been aimed also immigrants and Gypsy, Roma ethnic groups as well. So these people have received a disproportionate impact of the application of these regulations. At present, there is evidence of the increasing immigrant population and among homeless people, of course. So we have to have it very clear in our minds that homelessness has been defined on the basis of a situation of residence, not an administrative status of that person. So we can say that the group of people who are homeless is receiving an impact, an exaggerated impact in terms of these approaches by the authorities, and some of these homeless people are being victims of the application of this penal law of the enemy. It's a typical example, for example, acting in situations where health problems have emerged, and sanitation, so social services come in, local police, and the foreign or the border police, depending on the basis of the administrative structure of the people, not their needs. Unfortunately, that's the way the measures are defined. Sometimes they're expelled individually or collectively. So, this philosophy of exceptionality, and this has impregnated the work of the social services, the health services, and also the housing services. In many cases, penalties are given on the basis of the status of the person or other criteria. For example, the access to certain social resources. In a specific case of homeless people, we can find ourselves in a situation in which we can deny access to a shelter because they don't have the right contacts locally, which is happening in Holland. And I hope that our colleague from Holland will explain later, Mr. Sprakel. And then we penalise access to affordable housings because they've got a record of debts or they haven't paid their rent on time. So these are measures to penalise people. There are administrative obstacles that make it more difficult for people to access the right to decent housing. Now this forces us to analyse, if we would really want to understand the situation in penal terms, we also need to look at social policy, because at the end of the day, penal and social policies, as Bakwan says, are basically two sides of the same coin, i.e. management of poverty. To conclude, from what I've explained, we can say that the concept of penalization that we have used in this report is based on Bakwan's concept and was used by the United Nations, by the rapporteur on human rights and extreme poverty, which analyzes penalization as a series of laws, administrative measures and political measures that punish, control and segregate people who are in a situation of poverty. And this can be done directly through ordinances or regulations, or imprisonment or exclusion, and also indirectly through stopping people getting access to certain social resources. So, in this report, we've applied this concept to homelessness, and we want to see how these people are being criminalized. In many cases, they're having difficulty in getting access to housing, and in some particular cases, they're being put in prison or being expelled from certain areas or deported from countries. So, we're not saying there's a marked strategy, if you like, of some or a grey sort of force in the background, but there's a sort of penal framework being created that's very ambiguous, which depends on the political orientation that it might receive. We can find ourselves in the near future in a situation that are very worrying and which can remind us of what has happened in the past. So, the recommendations we're making within the for the European Commission and for the Parliament is that it's a question of making explicit and demonstrating their rejection, their concern and their sense of alarm about the ways of penalization and criminalization of homelessness. That we should promote training in human rights, poverty and homelessness at the different levels of the administration, European, state, regional and local. But also among the different stakeholders that are taking part in the solution of this problem, in setting up exchange experiences at European level, either including homeless people directly or ombudsmans or NGOs, different levels and different states. So we need to promote solutions of permanent housing which will allow us to break this vicious circle between people living in the street on the pressure and the shelter. So to conclude, I'd like to underline that homelessness is not a lifestyle. Nobody decides to live out on the street permanently. It's a process of social exclusion from decent housing. And we say this because the street kills people. We know it. And we're familiar with it. We see it every day. People continue to die out on the street because they're so out of society. And we also want to emphasize that prisons are not a good instrument to manage homelessness. Why? Well, prison also kills. They're not rehabilitation centres anymore. The rates of suicide inside prisons in some countries in the EU are very high. The percentage of personnel who are working in prisons, 80% in many countries of the EU, they're just working on control, not rehabilitation or education, of the people who are inside. So, I also need to emphasize that the entities that are working with homeless people and social movements have an obligation to make contact and to mobilize to the homeless people themselves. And also, there's many people who are not familiar with their rights. They don't know how to exercise their rights or can't do it for the situation in which they find themselves. And there are also other people, because they've been expelled from the system, if you like, that don't believe in justice. So it's our obligation to get closer to them. We have to empower them to report these situations and defend their rights. In principle, I'll leave it there, and thank you very much.
J'imagine que j'ai à passer la parole, effectivement, et je vais le faire après premier éclairage.
Thank you very much. And I would like to give the floor now to Adrian Perry. I don't know where you are exactly. Oh, you're there. And then there is a second presentation about the fundamental rights. You have the floor.
Very much. My task is to build on what Guillaume has said and show what we can do at national level and at the European level in order to entrench protection for homeless persons using the human rights tools which are available to us. I'd like to thank FEANTSA and Human Rights Watch for the opportunity to do this today, and it really is it's a pleasure to be among colleagues from so many European Union states who working together on these common issues of social justice for persons who are vulnerable to destitution. Just very briefly to tell you a little bit about myself. I'm an advocate working in London, a litigator working on issues of public law, social welfare and human rights. I'm also chair of the Immigration Law Practitioners Association in the UK, and we have a policy brief on migrant welfare, housing and homelessness. And I also have litigated cases on homelessness at the Court of Justice in the cases of Ibrahim and Texera on free movement rights and the associated housing rights for people exercising rights of free movement in the European Union. My brief is to look at the issues emerging out of the criminalisation and penalisation of homelessness and to see what we can do in terms of using human rights tools to push back on that process. There are questions of economic and social rights which are always much harder to litigate in principle, to use in domestic courts and in international courts. But there are also key issues of civil and political rights which may be being overlooked in the way in which policy is formed in relation to homeless persons, and also in the way in which both legislation and government policy is constrained. And as I hope to show you, under Title 10 of the Treaty on the Functioning of the European Union, the Commission and the Parliament, and indeed EU institutions as a whole, have a role to play in reminding Member States and coordinating the efforts of Member States to comply with the fundamental rights obligations that they have, both in their own constitutions and in the charters and conventions of human rights which apply. So we have a number of human rights protections in our national constitutional orders, and also in the European Convention on Human Rights, and also in the EU Charter on Fundamental Rights. The criminalisation and penalisation of homelessness, which Guillaume has been referring to, takes effect as he has outlined, in a number of national measures, which taken together breach the human rights of homeless persons, both in respect of legislation, which prevents them from sleeping and sitting and storing their possessions in public places, the use of rules which forces them to move on, measures which ban food distribution to homeless persons, measures the use of existing laws, of general laws, selectively against homeless persons in respect of measures to ban alcohol, for example, in public places, and the use also of existing public health measures to move homeless people on the basis that their presence on the streets might be a danger to public health. In all these contexts, legislation is being made either locally or nationally in member states, and also policy initiatives, administrative action is being taken by local and central government. And in all these contexts, we have the opportunity to look at these issues of social policy as they are applied through criminal justice and penalisation measures, and to use a human rights critique to take a number of practical measures to constrain these actions against vulnerable homeless persons who are vulnerable to destitution. All of these measures, banning people from eating out of bins, moving them on, preventing them from existing in public spaces in towns and cities, do not take away from the problem that the homeless person is merely displaced by these measures. He or she still exists. They exist in time and space. They have a subjective experience of being poor and socially excluded, and all these measures may be involved in governing the public realm in the interests of the broader society, but they take effect in the lives of the homeless person as a punishment for being poor and for being socially excluded. And so, when we come to look at the core human rights, which we find in our national constitutions, in the European Convention on Human Rights, in the Charter of Fundamental Rights, and in the International Covenant on Civil and Political Rights, we find a number of measures which we have readily to hand, which should inform the making of legislative policy and of government action before these breaches occur. It's not just a question of litigators, such as myself, bringing cases on behalf of homeless persons in an ad hoc way in order to constrain breaches of human rights. Human rights need to be embedded in the policy process wherein legislation is made and where government action and policy is formed before a breach of human rights occurs. And so we have measures such as the prohibition on inhuman and degrading treatment. In one form or another, it's an expression of the core principle of a commitment to human dignity, both in our national constitutions and in international rights, human rights instruments. It's an absolute right, it's non-derogable. In situations where people are prohibited from sleeping, eating, urinating or defecating in public places, core aspects of human dignity are infringed. There is a measure there there is an absolute human right which can be used to constrain policy and legislative action. Similarly, if criminal law is used to penalise a homeless person so that they're taken into detention, that measure has to be justified. The right to liberty and security, which takes effect in the European Regional System of Human Rights under Article 5 of the European Convention on Human Rights, prevents arbitrary detention, disproportionate use of detention. If a criminal measure or a measure such as an antisocial behaviour order with a criminal penalty attached to it is used, that can engage Article 5, the right to liberty issues. It's also true that a homeless person has the right to respect for his or her privacy and for their possessions to be respected. So the right to respect for privacy, as it takes effect under Article 8 of the European Convention on Human Rights, can involve protecting their possessions, the relationships which they have formed on the streets, and making sure that such few belongings as they have are not taken away, confiscated and destroyed by local or central government action. But perhaps the most obvious one, other than the right not to suffer from inhuman or degrading treatment, is the right to respect for the family and for the interests of children protected under Article 8 of the European Convention on Human Rights. It's often the case that when families are street homeless, that access to shelters is given on a gender-specific basis, that families are split up because either women have to go into one place, men into another, or children are segregated from them, either taken into local authority care or housed separately with mothers, and that fathers are housed elsewhere. In all of these cases, we know from the UN Convention on the Rights of the Child and from the general principles which we hold in common that the best interests of children must be considered first and as a priority. And in the formulation of homeless policy, both not just in terms of the manufacture of homelessness by government policy, but also in the responses to it, an Article 8 or rights compliant framework that looks at the right to respect for family life is a critical tool in measuring and judging whether or not a policy initiative is compliant with key human rights obligations. A couple of further rights which it's important not to neglect because they are the foundation of our common society and our plural and democratic society is the right to vote, which might not seem like the most obvious right when you're talking about homeless persons to be concerned with, but it is in fact the key core commitment of a democratic society, that each person who is enfranchised within the society has a vote, that vote is an equal vote and each vote has equal weight. If there are problems by being street homeless, with registration to vote, with requiring a residence in order to vote, then that measure can be infringed. And exclusion from the democratic process for homeless persons is not simply some fringe issue when you're otherwise destitute. It means that you're put outside the democratic mainstream. It shuts you out from the levers of democratic control for seeking to enforce your rights through the making of policy rather than simply through the courts. The final right, just to touch on briefly, is the prohibition against discrimination, whether it takes effect in equalities legislation or through measures such as no discrimination in the provision of the human rights, which I've already listed, or a freestanding prohibition, such as we find in Protocol 12 of the European Convention on Human Rights. And that too, the prohibition on discrimination reminds us that measures may impact differentially on people on grounds of race, on grounds of immigration status, where you're otherwise unlawfully present, on grounds of gender. It can also affect people disproportionately on grounds of mental health and on grounds of sexual orientation and other similar characteristics. So the challenge for us is to embed human rights practice in the making of legislation and social policy in respect of homeless persons, and to embed a human rights compliant practice just using the civil and political rights that we already have in our responses to homelessness. It really is an invitation to national governments to think before they criminalise measures which impact on homeless persons, before they penalise homeless persons and place their fundamental rights in jeopardy. It is of course the case that the person who is homeless is in a position of social and economic catastrophe, but that doesn't mean that civil and political rights disappear from the equation. And when we remind ourselves that the commitment to human dignity is a core principle which underlines and underpins the framework of human rights, the protection that we have in our common states, we appreciate that in fact the difference between social and economic rights and civil and political rights is really tissue thin, and they all form part of a web of comprehensive rights protection. We also need to remember, in developing a rights-based approach, that we need to make sure that the voice of the homeless person is heard, just as it's clearly understood that the voice of the child must be heard in enforcing children's rights under the UN Convention on the Rights of the Child. Without true participation in the formation of policy by homeless persons, it's unlikely that their subjective experience will ever be understood, and that proper measures which put an end to the needs caused by homelessness will ever be effected. In terms of what the EU institutions can do, it's clear that under Title 10 of the Treaty on the Functioning of the European Union, that the EU's competence is a limited one. It relates to, if you like, coordination through the open method of coordination, and the role of the Commission and of the Parliament in supporting Member States through a process of encouraging cooperation, facilitating coordination in the field of social policy, and adopting measures to encourage cooperation between Member States. But that task is one which requires, under the treaty, measures to improve knowledge, to exchange information, and to exchange best practice. Once it's understood that that best practice includes a commitment to making policy and making legislation which is fundamental rights compliant, it doesn't really matter whether you get those fundamental rights from the national constitutional order, from the European Convention on Human Rights, or indeed the Charter on Fundamental Rights. What matters is that those rights are enforced and embedded in national legislation and policy. And to that end, there is a key role for the European institutions given to them under Title 10 of the treaty to promote the embedding of fundamental rights in national state legislation and national state practice. And it's a measurable task which can be well understood because we see the state reports on homelessness, among other areas of social protection and social exclusion, which are available through the process of the open method of coordination under Title 10 of the EU treaties. And so there is an opportunity here, if not to harmonise, if not to legislate directly, to use the governance provisions of the treaty to make sure that homeless persons have their needs met in a fundamental rights compliant way, and that fundamental rights are actually used as active tools in order to make sure that the needs of homeless persons are met generally in all our member states. Thank you very much.
Thank you, Adrian. I am going to chairwomanship. Need to leave to go and vote. Thank you very much, Adrian, for your very clear and concise explanation on the human rights situation regarding homeless people in the EU. I am very sorry this is not supposed to happen. And also, Guillaume, thank you very much for your very deep analysis of the situation in the European Union as it stands now, and also the concepts that you have explained that have emerged over the past, I would say, 25 to 30 years, and the changes that you have noticed with within your research. I could imagine that there are a few questions to either Guillaume or Adrian on the research that they have done and the presentation that they have given. So I would like to give anyone the floor if he or she wants to pose a question. To the right side. Please introduce yourself.
Ian Johnson from the International Federation of Social Workers. I'm very pleased to be here because this is a major issue for us. And the speakers already have talked about the blame game, about the blaming of people for the problems that they face in society. And I guess one of the issues for us is not only the blame game of those people, but also how it's applied to those who try and assist and fight for the rights of individuals affected by this. I could talk at length about the concerns that social workers have about this, and of course you will know, most of you, that the case in Hungary where somebody was lost their job united social workers across Europe in a way that hadn't happened before last year. And I think that's really what brought us from social workers along to sessions like this. I was interested when I was reading the report to see the reference to public health ordinances, because it occurred to me that in the village that I live in, Scotland, we have no public toilets because the council have closed them. And instead of having a public toilet, they have made public houses where people go for a drink, the public toilets. But of course, if you are somebody who's not homeless but is imprisoned in your home because you have a disability or maybe an urgent need for the toilet, your rights are also abused. And I think that we might want to think about how we make connections between different groups who are quite far apart at the moment in terms of the failure of public authorities to properly provide services for everybody. So, thank you.
Thank you very much. Adrian or Guillaume, do you want to respond to this?
Well, only to really to endorse that, to the issue of the provision of public toilets in towns and cities is one that impacts particularly on people other than the homeless, as well as disabled persons and people who wouldn't otherwise perhaps wish to use a public house where alcohol is sold as well. It's a common thing in a political culture of austerity to cut back on something like that, as if it is discretionary. But in fact, even though it may not seem the most obvious civil and political rights issue, it is an issue of human dignity, and one which increasingly cuts across perhaps an issue on which common cause can be made by homelessness groups and disabled groups as well.
Thank you very much, Adrian. Another question from Joris Sprakel.
Well, not so much a question, but Guillaume invited me to say a few words on the Dutch situation, and I want to make use of that opportunity here. My name is Joris Sprakel. I am a practicing lawyer in the Netherlands, and we have a law practice that deals primarily with undocumented migrants and their access to social and economic rights, amongst others the right to housing. And what you see in the Netherlands is not so much criminalization, but much more penalization of being in a poor situation. Basically, you cannot access your rights. If you look at the right to housing, for instance, or the right to basic shelter, a roof over your head for the night, the Dutch law, the structure of the Dutch law says you're entitled to it. With one exception, the undocumented migrants. Then it goes to the local policymakers. The local policymaker can actually themselves set rules for access to the housing. And that's where ultimately the problem arises. If you look at cities, big cities in like Amsterdam and Rotterdam, that are sort of responsible for the bulk of the homelessness shelter in the Netherlands, they set a list of rules before you can actually enter a shelter. You have the rule that you have to be a resident of the Netherlands, which excludes undocumented migrants, but also you have to have a certain age in a number of cases. You have to have what is called a local connection to the region where you're applying for shelter. And that, of course, is a major problem not only for undocumented migrants, but basically any migrant that comes from outside of the region, and that includes EU citizens, for instance, that become homeless at some point. And then finally, and that is also a major problem, you have to have psychological problems. That's one of the criteria that they use, and that means that a huge number of people are excluded. If you're interested in reading more about this, then I can refer you also to the website of the Council of Europe, where there is a collective complaint pending before the European Committee on Social Rights. And maybe finally I can share also the flip coin to exclusion from entry into homelessness shelters. And that is a case that is pending before the courts at the moment, where I am representing an undocumented mother that has a child with a Dutch passport, so it's a Dutch citizen, and basically they're threatened with eviction because the mother has only 200 euros of income every month, and they cannot pay the rent. And this has gone on for a couple of months now. And according to Dutch law, you can actually evict this person from the house. I go to court and I ask them, so please take into consideration the rights of the child, take into consideration the right to family life of the mother and the child to actually live together in this home. And then ultimately what the city council says, they say, if these people are evicted, they can call for help and come to our emergency shelter. But of course that's the world upside down. That's basically getting from a situation that is good for the child and good for the family to a situation where ultimately this is it should be a temporary situation. It's not the solution to actually solving the housing problem of the mother and child. In this case, my view is still that the government should pay for the house. and not for emergency shelter. But anyway, those are some examples. I can continue for hours and hours with examples. I will not do that, but at least I have shed some light on that situation. Thank you very much.
Thank you very much, Joris. I think that explains it, and we will have some witnesses of being criminalized or penalized later on in this session. Freek Spinnewijn.
A question for Adrian, because you were talking about the right to vote and the right to be part of democratic life, and it seems far away from homelessness, but might actually be easily linked. I mean, there is, of course, the European elections. Maybe that's a difficult one, but there is another initiative which is related to being part of democratic life, and which is a truly European initiative, which is called the European Citizens Initiative. I mean, you have to collect a number of signatures, and then you can sort of force something on the agenda of the European Union. Now, we looked at the practicalities of organizing such a European Citizens Initiative. And you need, in at least, I think, around half of the countries, you need to have an address, or a permanent address, or registered somewhere. And that excludes part of the homeless population. Is there something we can do legally at EU level to force the European Union to make sure that every EU citizen, whether they have a permanent address or not, can take part in a European Citizens Initiative? And my second question is also for Adrian, about the open method of coordination and how it can be a framework for the European Union to intervene and to make sure that member states respect rights, also the rights of homeless people. But how do you force the European Commission to do that? Because I give you one example. There was mention made of the situation in Hungary, where homelessness is criminalized. The European Commission published a document in which they say that member states should not criminalize homelessness. Okay, that's simply a document. Recently, Commissioner Andor, who should feel responsible for this matter, went to Hungary for a conference about human rights organized by the European Commission and refused to say anything about the situation of homelessness in Hungary and the criminalization. How can what is there legal tools that we can use to force or at least encourage the European Commission to do what they should be doing in the framework of the OMC?
Both of those questions obviously touch on the practical exclusion which homeless persons face, both in terms of the measures taken by national governments, but also in the policy responses. As far as the petition question goes, there is provision under the title of the European Union treaties which deal with citizenship for legislation at EU level to buttress citizenship. It hasn't been much used, but it's the sort of, there is a lever for it, and it's possible for that kind of measure to be taken. The importance of equal access to European Union citizenship as an additional status to holding the nationality of a member state can only really be enforced if you have equal access to the benefits of such citizenship. So it would seem an obvious initiative to take up, that a requirement to have a residential address or to have permanent residence in a particular member state should be irrelevant to the exercise of those rights. And there's no particular reason why you ought to have a residential address. In a number of other contexts, the benefits of EU citizenship extend irrespective of your address. I'm thinking of the access to consular assistance of a member state if you're in a third country where your own country doesn't have any diplomatic or consular representation. So there's nothing tying the incident of European Union citizenship to presence on the territory in any particular place. So there could be scope, I think, for developing either secondary law or administrative practice to accommodate that if pushed forward and identified. On the question of how you force the European Commission to do anything, I don't think there is a legal lever which can be used. But what I do think can be done is to push the question of homelessness as a civil and political rights issue further up the agenda of the Fundamental Rights Agency, and to make it seem as an ordinary and, if you like, boring part of administering the open method of coordination. If you're going to put in benchmarks and have peer review of practices to combat social exclusion in member states, it's critical that the Commission is persuaded of the logic of administering a system where those benchmarks include the commitment to fundamental rights for homeless persons, and that effectively what's taking place is an audit of member state practice by those criteria of compliance with fundamental rights, rather than simply saying, well, you have a needs-based approach. What you seem to be doing is, in theory, comprehensive. Good luck. More is required. A more rigorous analytical framework is required. But I'm afraid it's a process of persuasion rather than of enforcement mechanisms using legal levers. Yeah.
Thank you, Adrian. It will be interesting to hear in a little bit the reaction from the representative of the European Commission who's present here today. I have another question, I think, from you. Please introduce yourself.
Yes, hello, good morning. My name is Olga Kozaeva. I represent Mental Health Europe. Thank you so much for the opportunity to be here and to listen to these really insightful presentations from these experts on the subject of homelessness. So on my side, it's more than an actual question, it's an observation that, so Mental Health Europe, we have among our members practitioners who work directly with homeless people. And what we observe is that really all homeless people are affected with mental health problems to some extent, and that it's documented that some 30% actually experience psychosocial disabilities, so severe mental health problems, and that we found that this poses an additional obstacle to these people to exercise their rights, to access health and social services, such as falling through the cracks. People who go to health services are then referred to homeless shelters and vice versa. So perhaps just to attract attention to this specific concept, and of course we fully endorse the rights-based approach as and empowering the people, the users, to provide adequate solutions to this issue. Thank you.
Thank you very much. Anyone would like to respond to this, or taking it as a comment? No? Okay, thank you very much. I would like to suggest that we continue on with the program by asking the representative of the European Commission, Mr. Vincent de Peigne, I hope I pronounced it right, to give his views, the views of the European Commission on the whole topic that has been raised by the experts just now.
Yeah, thank you. Thank you very much for this opportunity to speak. And I think the questions raised right now are interesting ones, and ones which I would like to address. I come from DG Justice, and I work specifically in the Fundamental Rights Unit. So that would be my angle, but of course I can answer other aspects or other questions as well. I think the first point is that one has to understand the way European Union law works and the inherent limitations when it comes to the particular topic we are talking about today. The EU is bound by a number, by the treaties, and its competencies can only extend insofar as the treaties allow. And I think the presentation we had just before put it quite clearly. And in that respect, this means that in terms of criminal law, there are limitations that the EU may act, but only in very specific and very limited areas under the Treaty of Lisbon, in particular in areas relating to cross-border crime, for example, terrorism or trafficking, etc. And this has a particular implication in terms of fundamental rights, is that the Charter of Fundamental Rights applies within the scope of EU law. And They are clearly provisioned in the Charter of Fundamental Rights in terms of civil, political rights, but also in terms of housing assistance and of social rights. So there are certainly a great deal of rights enshrined in the Charter which can be used in the context of right to housing and all the rights related to housing. But again, there has to be a link with European Union law. And this is where probably the issue lies in terms of a legal approach. There are a number of hooks or a number of areas where the right to housing and civil and political rights, the right to an effective remedy, I mean, all the rights enshrined in the Charter may be of use, and there are a number of contexts which relate to free movement. Citizenship was mentioned. Also migrants, the right to, in particular, long-term residence. There is a directive which has a number of rights for long-term migrants. One can also mention the anti-discrimination directives. I mean, in particular, Directive 2043, which deals with non-discrimination based on ethnic origin, and which include also access to housing. The Commission has tabled a proposal for a directive to extend the non-discrimination principle in access to services, including housing, to other grounds, which could be age, disability, religion, etc. I mean, to other grounds, but this is still under discussion in Council. So these are a number of areas, and it should be noted that in one case, in the case of migrants, of long-term migrants, the Court of Justice has relied on the Charter, on Article 34 of the Charter, to clarify that the right to social assistance, which the long-term migrants have, should include also housing assistance. And that was relying precisely on the Charter. So there are ways within the scope of EU law to make use of the Charter and to make use of these kind of rights, but again, they are limited to a number of specific cases. Now, of course, and this was mentioned, there are also the policy, the coordination role, or the policy that the European Union can undertake in the area of employment, of social issues. There has been the social investment package. There have been a number of policy documents. There is also the actions of the EU in favour of Roma inclusion, which include a strong element in terms of housing. So these are areas where the Commission works not through legal means, but rather through recommendation or through policy. So we are not here putting any obligation on member states. We are putting a number of recommendations and monitoring what member states are doing. And here the Commission has been quite clear that as a matter of policy, the criminalization of homelessness is simply inefficient, ineffective, and that's not the way to address homelessness, and that there are other ways, and principally through proposing alternative means of housing and a number of policies which were underlined and which were discussed just previously. Again, this is more a policy approach where the only means we have to put pressure on member states is through incentives, through public discussion, and through, in particular in the case of Roma, there are commitments that member states have to undertake and which are monitored and which can be then discussed, and then you can show which member states are faring better than others, etc. And you have some benchmarks, but this is a different approach from a strictly legal approach. So I think that was, in a few words, what I wanted to say. I'm happy to answer questions.
Thank you very much. I wonder if there is anyone from DG Employment here present today who would like to respond to the possibilities that you've just sketched for us.
Hi, I'm from DG Employment.
And
my micro is not working. Yeah. I'm Agnes Nirai. I'm dealing mainly with Hungary. I'm Hungarian as well. Yeah, I'm just would like to add that linked to the policy measures what try to be made, the European Commission is also an other financial approach what we can touch. That is, there is main budget, the ESF budget, what to support many social issues. We know that. But there is also another one what is just approved by the Council, the FED, probably you already know that, the Fund for the Most Deprived People. It's a separate budget for from the ESF budget, and the share and the allocation among the member states is not yet approved, and it's not clear still, but it's consequently, and it's 3.5 billion euro allocated among the member states.
Okay, thank you very much. I would like to invite Madame Beres, who is Member of Parliament of the European Parliament and also the Chairwoman of the Employment and Social Affairs Committee, to briefly react to the different speakers that she has just heard.
Yeah, thank you, and well done for organizing today this event. I think it is critical to do it, and it's also critical to do it right in this moment, because in the whole EU story, we are at a moment where the Commission is to come out with a proposal on the social dimension of the economic and monetary union. So I think here, if we are consistent, we will really have to put some emphasis in the logic of what was designed in the EU 2020 strategy regarding the fight against poverty and social exclusion. This means going through the line that the Commission is just preparing not only for this global or transversal document, but also the way out next year. The Commission will look at the policy implemented by Member States, which is documented by the annual growth survey. And this year, for the first year, the Commission has pointed out Member States' situation where the fight against poverty might be an issue. And I think the fact that we are fighting for social indicators, for example, that could count the number of homeless people, would allow then the Commission much more to monitor the situation of Member States where this situation is not looked at carefully enough. When it comes to your main topic about the situation of homeless people inside the Union and the kind of sanction they can be victim of, I think it's really a point where, as a former member of the Convention on the Charter of Fundamental Rights, I do remember the discussion we had at that time when it comes to the housing right, and the discussion we had, should we write this access to housing, and the whole debate we had notably with UK regarding how a court could oppose or not this right to a government, namely. And I think this debate is still going on, because on the one hand you have the whole definition of public services and social housing, and on the other hand you have the issue of the access. And I think this question of the access is absolutely of the essence. And sorry to go back to my souvenir, but I remember one of the first alert we had when trying to have this whole package for social dimension in the Fundamental Rights Charter. It was the director of ATD Carmonde that at that time told us, well, what is a right, what is a liberty if you don't have a housing? And I think this really is now in the heart of our discussion. And here I think there's one point also that you should have in your basket as an argument, that of course when you look at the situation in Hungary, and obviously it's been one of your starting points for this action today, what is really striking for some of us in the Parliament is the unbalanced situation in terms of sanction and in terms of recall of what are the rights when it comes to fundamental rights on the one hand, and what is done in terms of a sanction regarding the Stability and Growth Pact. Because for the Stability and Growth Pact, the machine goes on, straight on, but when it comes to people's right, also as homeless people, it is more of an issue at the EU level. So I think this, the whole campaign you're now launching is more than important. And as you know, maybe you don't know, but let me just inform you that in the Employment and Social Affairs Committee, I think we've been fighting through at least two reports that might be a good point to support your campaign. One is a resolution we've been passing through in the plenary of the Parliament on the 14th of September regarding the strategy of the EU for the homelessness. And the other one is the one on the impact of the crisis for the most vulnerable people. And I think this is also something we can build on. If I may add to your to-do list, I'm quite sure you already have a lot of ideas where to lobby, where to fight for. But if I can add some element on this list, it would be that the situation of the homeless is among the issue where we will elaborate some indicators at the EU level. That's the first one. And then the second one would be, of course, the use of these indicators. This means that when these indicators are settled, that it can be used for the country-specific recommendation. Sorry to be so concrete, but I think this is also how, as the chair of the Employment and Social Affairs Committee, I can help you in this very important campaign you're going on.
Thank you very much, Madame Beers, and I think that very concrete suggestions for lobbying or getting involved are exactly what we need and we're trying to identify during this meeting, and it's clear that a lot of work needs to be done. Thank you very much for your intervention and your presence here. There are a number of European networks who have accepted the invitation to be here today, and they are mentioned in the program for today. And I do not know all of these representatives in person, but if any one of them from the AIR Center or INAR would like to give their views on the whole issue of criminalization and also the recommendations, suggestions that have been done by the different speaker up until now, please do so.
Hi, I'm Matt Moriarty from the AIR Centre. We're based in London. We're a specialist legal charity that deals with EU law and human rights law. I was going to just talk briefly about some of the cases that we've run, which would be relevant to applying human rights law to homeless people across the EU. But I thought it might be interesting to note, for those of you who don't know, that the UK actually actively and quite aggressively does criminalise homeless people at the moment. There's the Vagrancy Act 1824, which, although is nearly 200 years old, is still considered good law in the UK. Under the common law system, it's not been repealed. And perhaps even more shockingly, we've actually heard anecdotal examples of it being used against people this year. In one case, a young man was reportedly imprisoned for 4 weeks for being in a bin in Nottingham, where he was presumably looking for food that had been discarded. And more recently, just a few days ago, some Roma citizens were moved on from various central parts of London under the threat that if they didn't move on, or if they didn't accept the insufficient accommodation that was being offered to them, they would be criminalised under the Vagrancy Act. They'd be charged with 200-year-old criminal offences. And if you read the Act itself, it really is shockingly anachronistic, but it hasn't changed at all in those 189 years. It's exactly as it was, and it's being applied in criminal courts in the UK now. We also have Section 144 of the Legal Aid, Sentencing and Punishment of Offenders Act, which came into force around this time last year, which specifically criminalises squatting in residential properties. it was quite an easy win for the coalition government to push this through. They rushed it through the parliamentary process. Squatters are particularly unpopular with the mass media in the UK and therefore with the general public by and large. But it's actually been applied invariably to criminalise young, vulnerable people who are staying in completely vacated, totally empty properties and are causing no harm to the owners or to the public at large. In fact, they're off the streets, they're safe, and they're staying out of people's way. And yet they're being locked up, in some cases, for utilising those vacated properties. I have to say the Air Centre has not been actively involved in those particular cases, but what we are involved in is the more kind of discreet penalisation of EU citizens who are homeless in London and in the UK more generally. I know Guillaume talked about this process of removing people or expelling them from EU member states. And we've taken on a couple of cases, one in 2011 and one in January of this year, of people who were homeless EU citizens who were picked up by the UK authorities and basically told that because they weren't actively exercising their treaty rights, they could be removed back to their respective countries. In the first case, it was a Czech national who had actually been in the UK for over 5 years, and her partner had been made homeless in very unfortunate circumstances, and she'd actually started selling the Big Issue as a way to support herself. She hadn't asked the UK authorities for anything. Then she went and claimed job seekers allowance in order to assert her treaty rights, and shortly after that she was told that she didn't qualify as a job seeker because she didn't have a right to reside in the UK, which is a whole separate issue, which happily the European Commission is actually doing something about quite proactively at the moment. In any event, we took the case to the Social Security Tribunal, the Immigration Tribunal, and it was found that it was disproportionate to remove her to the Czech Republic under Article 8 of the European Convention of Human Rights, not least because, had she been removed to the Czech Republic, she had a presumptive right to re-enter the UK and exercise her free movement rights immediately after she'd been removed. So it didn't achieve any legitimate aim whatsoever to remove her from the country. And similarly, earlier this year, a Polish national who had been here for 3 years and was selling the Big Issue was found to be self-employed on the basis of selling the Big Issue, on the basis of the case that we ran in the Immigration Tribunal. But also the immigration judge made it very clear that his expulsion could not achieve a legitimate aim, even though the Home Office tried to argue that one aim they were trying to pursue by removing this homeless man was to combat homelessness in the UK. So effectively, if he's homeless somewhere else, we've dealt with homelessness. Thankfully, the argument wasn't accepted. But it's perhaps also interesting to note that in both of these cases, the Home Office failed to exercise their right to appeal to the upper tribunal or indeed to the higher courts. You might think because they didn't want these cases to be binding case law and they didn't want these cases to be widely reported. So hence, there may be a huge number of other homeless people out there who wouldn't be aware of these cases, whose NGO support workers or legal representatives wouldn't be aware of these cases, and who very may well have been unsuccessful in the Immigration Tribunal. So I do think the European Convention of Human Rights can be very useful still, but I think perhaps, based on what everyone's been saying so far, I think the Air Centre's view is that the EU Charter could be much better utilised, particularly in social assistance and social welfare cases, to try and assert the rights of EU citizens, because if being an EU citizen is nothing more than being allowed to exercise your treaty rights, then really the EU Charter is effectively rendered impotent, and we feel very strongly that we need to push against that in the Air Centre. So I'm very grateful to have been invited here, and I really look forward to reading the full report.
Thank you very much, Matt, that provides some insight in what's actually happening on the ground, what's happening to accessing rights and actually using European law that's available for European citizens, but that doesn't seem to be implemented or recognized as an instrument for people to access their rights at this moment. So I think the to-do list that Madame Beres referred to is getting longer as we speak. I don't know if someone from INAR is present here to give his or her view on the situation. I know that they've been invited. If not, then I suggest that we have a very brief 5-minute recess to stretch our legs, because 3 hours of sitting and listening is quite exhaustive. And then we reconvene at 11:45 in this room. Thank you. Welcome back, everybody. We would like to start the meeting again. I'm giving over the chairwomanship to our Member of Parliament, Madame Sylvie Guillaume, who fortunately returned from the voting.
Oui, mais je suis revenu.
Yes, I came back from the vote, but what was important, I had to go. So, here we are again then. I've picked up some information on the part of the meeting I wasn't, when people said it was really animated and interesting. So let's continue now with listed a few cases or studying some situations. So shall we keep the same order of Hungary, Greece, and then French? So let's start with Hungary.
Okay, thanks a lot. I'm Stefania and Capronței, and I'm representing the Hungarian Civil Liberties Union. I would like to thank FEANTSA and Samara Jones for organizing this event, and all of you for participating and for your very insightful comments. So my task is to introduce the case study of Hungary from a legal standpoint. I apologize in advance if it will be a bit boring because it's a legal introduction to the whole issue, but I think it resonates with what was said by Adrian and Guillaume before. I'm representing a human rights organization, the Hungarian Civil Liberties Union, so my approach is from this standpoint, from a human rights standpoint. The HCLU, this organization, was involved starting from 2008 in classic legal advocacy activities concerning the criminalization of poverty. First it started with criminalization of begging, and then dumpster diving, and then we arrived to criminalizing street of homelessness. So in my brief statement, first I would like to address two major questions. One is that what is the legal environment in Hungary regarding the criminalization of street homelessness? And second is about the ways in which the HCLU, traditional legal advocacy NGO, has cooperated with the City for All, a grassroots organization, and also with the umbrella organization for service providers, the TISAC. So regarding the first question, I will not cover all the details of the history of criminalization. However, I would like to highlight few events just to illustrate the broader context in Hungary, namely the shortcomings regarding fundamental rights and constitutional principles that were also addressed in the so-called Tavares report that was adopted recently. The Hungarian case study illustrates the ways in which politicians hope to gain popularity with insisting on criminalizing people who allegedly infringe public order and other characteristics of criminalizing poverty that was described by Mr. Fernandez. After a long history of criminalization attempts, last December the Hungarian Constitutional Court pronounced that it is unconstitutional that the Act on Petty Offences declared habitation in public areas, street homelessness, living on the streets, a petty offence, and imposed imprisonment as a sanction. Later, in 2013 already, the Parliament adopted an amendment to the Hungarian Constitution, which enacted, among other issues, that an Act of Parliament or a local government decree, so basically law, may outlaw the use of certain public space for habitation in order to preserve public order, public safety, public health, and cultural values. I will come back to this listing. The government hoped to remedy the deficiencies of laws criminalizing street homelessness by simply amending the constitution. And this is important because the violation of fundamental rights, I argue, cannot be simply remedied by rewriting the constitution, because these provisions in question continue to violate the right to human dignity that is not only set forth by the Hungarian constitution but also various European documents. The Hungarian Constitutional Court ruled that it is incompatible with the protection of human dignity to penalize people who live on the streets. But it seems that the decision makers are deaf to concerns regarding human rights and the possible impact on the life of people who live on the streets. So despite this broad opposition to the amendment of the Constitution, it was adopted by the Parliament. And based on this amendment, now the Parliament debates another amendment to the Act of Petty Offences, which will enact the detailed rules on the ways in which municipalities, local governments can declare habitation in public spaces illegal, basically living on the streets illegal. So, and the final vote will take place in 2 weeks. Even though the new regulation seems to be milder than the outright ban on street homelessness before, these only seemingly mitigate the situation. Just to give you a few examples, the new regulation, if adopted, will introduce obligatory warning before a procedure can be initiated against the person who lives on the street. And it also adopts the definition of living on the street, of habituation in public areas. But both of the above provisions, I believe, will result mainly in continuous checks and searches, harassment, if you will, against people who live on the streets. Another aspect that I would like to highlight is that the new regulation will include reasons for declaring illegal staying in public area as a permanent dwelling, such as public order, public security, public health and cultural values. But all of these terms are very vague, and it is worrisome that the restriction of fundamental rights can be based on such vague terms. And also I mentioned that the municipalities can declare that staying on the streets, living on the street, is prohibited or illegal in specific parts of their territory. There are numerous problems with this provision as well, but I would like to highlight one, that this provision exposes the real reason behind the legislation, which is regarding tourism and the way the city shows itself. If any other reason was to be taken seriously than this, why only specific areas would be considered? The sanction will be community service. But however, for those people who commit this offence, again, for recidivists, and please note the irony in this, it will be more severe, up to 6 months imprisonment. The mayor of Budapest has already announced that they are only waiting for this act on petty offences to be adopted by the parliament, and then they will pass already the legislation for Budapest. So this is a real threat, and not only on the political level. So, and then few words about how the HCLU, this classical legal advocacy NGO, has cooperated with the City for All. Basically, this comprises of 4 activities. One is providing legal expertise and know-how to advocacy activities. This included also submitting petitions and submitting opinion letters, but also providing legal consultants in freedom of information request. The second type of activity was trainings for the City for All members. These included formal trainings on the one hand, and also regular counseling on legal matters. Thirdly, we cooperated regarding strategic litigation activities. We prepared for taking a case of an individual complainant to national and international forums. And the fourth type of activity is raising awareness among the public, and this included writing blog posts and articles, and also stemming from our very diverse portfolio at HCLU, we also prepared a short film to document the process in which homelessness is criminalized in Hungary. So to end, I can only echo the points that Adrian ended on, and in particular, I'd like to call the Hungarian legislator and also the European Union institutions to take the necessary steps in order to ensure that the right to human dignity for homeless people in Hungary is promoted. The promotion of fundamental rights is of utmost importance when such vulnerable populations is the target of such restricting legislation. And I would like to ask everyone also in this room to spread the news about what is happening to these groups in Europe and in Hungary. So when Mr. Andor on a conference is not willing to respond to go into details about this, then there will be someone who asks questions about it. And now I would like to give the floor to my colleagues.
Thank you. Hello? Okay, that's right. I'm Levon Kardos from the Umbrella Corporation TISAC and Household. The criminalization of homelessness started in the autumn in 2011 when the local authorities received the power to define what is to be considered antisocial behavior in their territories, well as sanctioning those types of behavior with fines and in case of non-payment, public employment or imprisonment. Several local decrees were accepted that especially targeted the homeless people and those living in extreme poverty. For example, forbidding drinking alcohol in public places, looking into a garbage bin, or sleeping row, or keeping one's belongings in public spaces. The first punishment was in Budapest, the capital, where the 8th district, this is one of the poorest areas of Budapest, with a very high rate of unemployment, accepted a ban on occupying public spaces for living purposes. As a result, there was a coordinated police action was launched during which almost all homeless people found in the districts were taken to a special police station set up for this purpose. Most arrests had no other reason than finding homeless people in this area outdoors. One of the first decisions contained the following as the reason for police action. At 8 in the morning of September the 3rd, this person and several of his acquaintances were found sitting on a piece of stone in the vicinity of the railway station. Unfortunately, he admitted to sleeping row for approximately 9 years and spending most of his time around the railway station. As a first-time offender, he only received an oral warning telling him that if he caught committing the same demeanour again, he will be fined to an equivalent of 170 euros, an amount more than twice of the basic social benefit many homeless people received. Some homeless people have an even smaller income. Not all local authorities used the possibilities to create the similar decrees forbidding row sleeping, but still several districts in Budapest, as well as other Hungarian towns like Tatabánya, Pécs and Kaposvár followed their suit. The real problem was brought about by the modification of the law of petty crime, in which row sleeping, occupying public space for living purposes, was specially mentioned. Even though no definition for living purposes was provided, the highest amount of fine for this misdemeanor was raised to 700 euros. As we know, any piece of legislation is only valid once it starts to be applied. Unfortunately, some towns were very aggressive in their application. I would like to share 4 examples which, in my opinion, reflect well how serious the results of the criminalization of homelessness can be. Ferenc, he's a 60-year-old man. Between July and September 2012, he was fined 31 times for committing the same misdemeanor, that occupying public space for living purposes. So it was 31 times. The police knew exactly where Ferenc spent the night and visited him regularly, sometimes several times one a day, within the span of a few rows. The ticket he received contained almost the same words every time. While going on my regular round, I came upon the named person who was sleeping by the wall on the ground, his personal belongings around him. None of the tickets mention any other petty crime, such as littering, begging, or antisocial behavior. Ferenc was sleeping in a place hidden from passers-by, so he didn't even disturb anyone. If he received the ticket for equivalent of just 170 euros each time, altogether it will be 5,270 euros or 310 days of public employment or the same days in prison. Ferenc is not capable to work. He had no income during this month, so his only choice would have been imprisonment. His sentence was abolished after the Hungarian Constitutional Court annulled the paragraphs in the law on petty crime criminalizing homeless people. He now takes part in a program similar to Housing First. He receives social benefits, which doesn't enable him to keep his housing once the project funding runs out. However, with a debt of more than 5,000 euros, or having to spend almost a year in a prison, his chances of integration will diminish to zero. Another example, János. He's a 57-year-old man. He sleeps hidden behind the backstairs of an abandoned building every night. The policeman knew him as well, so within a short time he had accumulated a hefty fine. Being a low abandoning citizen, he spent 72 days with public employment, which had paid in kind for his fines amounting to about 1,200 euros. As he had no income at all, he was lucky to be in good health, so he could pay for his fine through public employment. He now receives social benefits of 70 euros a month. Because of the lack of employment opportunities, he still hasn't no means to pay large fines should police start harassing him again. Zsuzsanna, she's a 68-year-old woman. She used to be a teacher's assistant in a small settlement, but has been unemployed since 1989. She had received 27 tickets. Just in August alone, she was fined every third day, altogether 11 times. 2 times she was fined at the same day, within an hour. Police visited her at the same time each day, as they knew by her daily routine that she would be there. She has no income and she is incapable of work both mentally and physically, so she surely would have ended up in jail had the Constitutional Court not abolished the paragraphs of petty crime, law banning, law sleeping and all pending lawsuits with it. Zoltan, he is a 27-year-old man. Due to an accident, he is physically disabled. He can only speak through a speech valve, which makes any communications very difficult. He also has several psychiatric problems, which prevent him from giving clear answers to the policeman. During the winter, he was fined twice, to a total of about 150 euros. It was very interesting because in this time he's sleeping in a low threshold night shelter at the fall time in the whole winter. So he was fined for using public space during the daytime. According to the data provided to the Hungarian Civil Liberties Union, the law criminalizing homeless people was applied in 2,100 cases, out of which fines were issued in 1,543 cases, amounting to about 133,000 euros. Even though the Constitutional Court annulled the paragraphs criminalizing road sleeping, homeless people still get fined for misdemeanors relating to the cleanliness of public place or aggressive begging. These rules are mostly exclusively used in the case of homeless people. Outreach teams have met people who were fined for littering outside the metro station that they were sleeping at. Many people threw their tickets on the ground. It didn't matter that they told the police it was not them who had used the tickets, as they had no money for that. In another case, the policeman asked for the ID of a homeless man he knew well, and whose ID he had checked only a day before. When the man became upset and used the bad language, he was fined for assaulting police. He then got even more angry and threw the ticket on the ground, for which he received an additional fine for littering. We know people who had been fined for occupying public spaces for living purposes because they had their belongings with him during the day. Even though they slept in a shelter at night, they couldn't leave their things there during the day. Others were fined after the police asked them to empty their pockets, and they couldn't produce a key for a home. So the police assumed they were homeless. Regarding our experience until these days, we fear that local authorities will use the power now granted them in the Constitution to ban road sleeping in certain areas. The first such decree is to be voted in the City Hall of Budapest any day now, which plans to banish homeless people to the outskirts of the city. It's not unlikely that other towns will follow this example, and no one can foresee what results these actions might have. Thank you.
So, third intervention on the system, on the situation. My name is Laszlo Kardos. I'm an activist of the City for All. The City for All is a grassroots organization of homeless people and their allies who fight for fundamental human rights, including the right to housing. We would like to draw your attention to one of the most severe social problems in Hungary, that's homelessness. We want to achieve a comprehensive and systemic change in our country that allows us, the most vulnerable social stratum, to realize their human rights and attain housing of human dignity. Criminalization. Today in Hungary, homeless people live in a stigmatized, humiliated way, and also in fear. They're not able to practice their citizenship rights and need to run away and hide from authorities. Due to fast punishment, tens of thousands of people have become homeless since the social economic transition, and this process goes on even today because there's no adequate housing strategy in Hungary that will guarantee the possibility of a normal human life for everyone. Tens of thousands of people are forced to live on the street or in homeless shelters today in Hungary. The shelter system can provide accommodation for a fraction of these people because it lacks adequate capacity. Anyway, the homeless service cannot provide the basics of an adequate life. The shelters are overpopulated. Often people need to sleep on the corridors. People rather choose the street for this reason, among others. On the other hand, institutions of the homeless service system hospitalize their users, since they cannot provide solutions that would help them escape the situation. The programs are not functional because, due to the lack of viable alternative in most cases, the participants find themselves on the street again in the end. According to the planned amendment, the authorized will be authorized to fine people who do not have a chance but to live on the street. They cannot pay these fines, therefore they will very likely end up in a prison. Imprisonment obviously deprives homeless people from their possibility to carry out their fundamental citizens' rights and causes long-term harms too. With a prison experience, they would have no chance to find suitable employment, so they remain without income, so they don't have any real chance to reintegrate into society. And there are areas in Budapest today where if a homeless person sits down, police officers immediately appear and send them away. This is humiliating and violates people's basic rights. Those who eat at charity food provisions on the street often face harassment by the authorities. The police officers presuppose once a crowd, there's a criminal. So there's always people waiting in line. The only sin, however, these people is that they're hungry. Anyone who dares to criticize the practice sometimes gets threatened. I've experienced this myself. I filed a complaint, but nothing effective has happened. So there are three possibilities for rough sleepers in Hungary. The first one is to use a shelter voluntarily, provided that one can find that you've got a free bed and accept the fact that even the basic necessities of human life are barely provided there. I myself live at such a place, so I know what these people face day to day. Privacy is lacking, the shelters are often unhygienic, full of insects, thefts happen all the time, and the circumstances are not suitable for autonomous living. One example. At one of the shelters in Budapest in the winter crisis period, a poster was telling the inhabitants that chatting is forbidden. This doesn't suggest autonomous living to me. The second chance is just to stay on the street and live in fear of being fined, which is the same as imprisonment, as people have no chance of paying these high fines. This obviously violates the fundamental rights of the people, and they would also need to live stigmatized by imprisonment for the rest of their lives. The third possibility is running away from the authorities and hiding as a criminal. This is very dangerous, though, because due to the constant moving, nobody is aware of the person's whereabouts, so their life could be in danger, especially from like hypothermia, and in these circumstances they can't get help. Today, in Hungary, the constitution does not set the fundamental rights of people, but legitimizes the persecution of homeless people. Hungary, as far as we know, is the only country in the world with such a practice. The Minister of the Interior has proposed an amendment on the Act on Misdemeanors. If it came into force, would lead to the need for many homeless people to run away and hide. However, the solution to such problems is not violence, but an adequate policy, housing policy, that aims at providing housing for the people, not selling out real estate property, and that supports the housing of every citizen, not just the upper and middle classes. All that money is spent on harassment, persecution and storage, in inverted commas, of the poorest and the most oppressed strata should be used for other ends. Ends that serve the solution of the problem. This amount could support the housing and ease the living problems of hundreds of thousands of people. So what has the City is for All done to oppose the criminalization of homelessness in Hungary? We have tried to draw attention to these problems in plenty of we tried to draw attention to these problems in the press releases. We've sent letters to the Hungarian MPs which highlighted the inadequate solution of the problem and asked for their support, but we haven't received any meaningful response. We've tried to voice our views in Parliament committees in vain. We were either not allowed to speak or our opinion was not taken into consideration. We have turned to law enforcement authorities to discuss these issues, but no success. We have initiated petitions targeting decision makers, not much success. We've organised a hearing for politicians. They didn't come. We've organised demonstrations one day with more than 500 people laying down in front of the Parliament to demonstrate solidarity with homeless people. We've turned to the ombudsperson who examined and accepted our complaint and passed it to the Constitutional Court to revise the law that criminalises homelessness. Then we won a little battle in the big war. The Constitutional Court repealed the law as being unconstitutional. As a reaction to this, the Hungarian government set criminalization of rough sleeping in the constitution. And then we organised a demonstration in which we practiced civil disobedience to draw attention to the problem. All the participating activists were taken to short-term arrest and were detained. So, what has the Cities for All done at the EU level? We've contacted individual AMPs asking their support, but unfortunately we haven't received any response. We've contacted the Fundamental Rights Agency, but again, unfortunately, we haven't had any answer. We've met the Cabinet Commission Andor in Budapest, and then we've sent our international call for support to the Cabinet. He informed us about the very limited possibilities of the Commission to intervene, i.e. issuing recommendations to the Hungarian government and drawing attention to the means of the European Social Fund. We've also contributed to the report of the Venice Commission. We were glad to note that the Commission's final report didn't criticise the practice of regulating homelessness on the Constitution. However, this report does not contain a moral statement about the criminalisation of homeless people. We've also issued a contribution to the Tavares report as to the fact that the criminalisation of homelessness violates fundamental EU values and rights. We were pleased to be informed that this issue was part of the final report. And now we're here to ask you in person that the European Union consider the criminalisation of homelessness just as serious a violation of fundamental union rights and values as the other anti-demic measures of the current Hungarian government. The persecution, humiliation and incarceration of people living in poverty is one of the most severe harms to democracy. The system based on the equal dignity and participation of each and every citizen. And a final thought. The Minister of the Interior has claimed in public that he wants to establish order in Hungary. I can say that the Cities for All wants order too. An order in which everyone's fundamental human rights are respected and no one needs to live on the street. We can bend the solution of the current conundrum by means of violence. So, I ask you to think about what you've just heard and support us according to your possibilities. We hope that our common struggle will achieve its goal and the most vulnerable inhabitants of Hungary will also be able to claim that they have fundamental human rights and that they are full citizens of the European Union. Thank you very much. Thank you. Would you like to intervene? If a little question what you said, because I haven't been in contact with your association. I haven't been in contact with your association, but I have a question for you. I think this illustrates very well something that's you said just now, the sharing of a certain amount of information. You referred to the Tavares report. I know the Parliament worked hard on that, on the determination of what could be forbidden. And I think the Tavares report has done some good work, and it's given fruit too, because there's been progress, modifications. Some of the laws that have been passed, well, some of them have been repealed. But I was reading recently that in Hungary, I think that there's a text that said that if there was at the European level measures which would apply against Hungary, and that should be taken into account by the Hungarians. And I know in certain sectors the pressure in the Parliament and in the Commission, we need to continue to exert this pressure. And the law that you speak about there's a strategic problem here, because we have to be clear, the action that the Parliament or the European Union in general carries out to vis-à-vis the power in Hungary must guarantee success. It must be successful. I don't want the present Prime Minister he's finding good excuses for all the situation. We don't want him to benefit from the failure of the European initiatives. No, he insults the European Union, but I've got the impression that when Europe does take an initiative, but it's not well perceived in Hungary because Mr. Orban he victimizes, becomes the victim, and if we don't take action, the European Union is criticized because it's not acting. So I think it's not. It's very important that we should coordinate between civil society and the political levels. Any actions that we need to carry out must be guaranteed success in Hungary, and I'm very attentive to the situation. I'd like just to make that comment because I think there's a political will that is something we can share. Are there any more questions planned for this? I see the time is going. There are two more interventions now. There might be 2 minutes. Shall we go on to the second subject? This time we're going to look at the situation in Greece and the violation of rights after austerity measures. Olga, over to you, please.
Thank you, and for this opportunity to give you a short description of the current situation of social rights in Greece. The ostensible aim of the austerity measures and adjustment is to reduce the fiscal deficit, reduce labour costs and make the economy competitive. However, until now, in Greece, these excessively rigid measures have resulted in the contraction of the economy, as well as significant social costs to the population. Greece has now the highest rate of persons below the poverty line in Europe. Approximately 21% of its population earn less than 60% of the median income. Among the unemployed, the poverty rate is nearly 59.2%. While among children it is estimated at 43.8%. Greece also remains the only country in the Eurozone where a comprehensive social assistance scheme serving as a social safety net of last resort is missing. These increasing stark inequalities are widening and associated with many other social ills. But the increase in the number of suicides, the neo-homeless, the increased delinquency, the economic insecurity are not just the effects of a state in crisis. They are the logical consequences of a pathogenic system cut off from social reality. Greece has assumed various international obligations through ratification of a number of core international and regional human rights treaties. Greece is also a state party to the European Social Charter. Furthermore, basic human rights such as housing, the right to work, to education, to property are guaranteed by the Greek constitution. Nevertheless, some of these basic guaranteed rights, including political rights, the right to vote, the right to elections, particularly also socio-economic rights, are under threat or being undermined by the imposed policies. What should be noted whatsoever is that this impact, these harsh facts, are not just the consequences of the fiscal crisis and the measures that the Greek government has to implement in return for the bailout. The Greek social and political system intertemporally lacked a human rights-based approach that would guarantee social cohesion and equality. A weak social security system where the protection of human rights is considered a luxury didn't have any way the mechanisms to protect the vulnerable ones in difficult times. The human rights are degraded by the lack of the social state, while measures that don't conform to social justice undermine social cohesion and democracy. The complex of unforeseen conflicting financial measures exacerbate the general insecurity. The majority of the Greek population faces the drastic reductions in wages and pensions, the rapid increase in unemployment and general job insecurity, the lack of effective infrastructure, the lack of family support, employment in poor and unsafe conditions, the mismatch of taxes and ability to pay, the inadequacy of legal aid for access to justice for the economically weak. The crisis has affected also the detention and imprisonment conditions, the policies towards immigrants and minorities, as well as relations between police and the public. Especially on housing, except the effects of the crisis, the long-standing issues of low quality of the urban environment, namely the absence of social housing sites and services provided at public expense, as well as the general lack of public and social infrastructure, which complements housing, haven't still been met by the social state. Although in Greece home ownership is still at high rates, homelessness increases. There has been an empirical estimation of 25% increase of homelessness during the last 3 years, and the crescent taxation as well as the threat of disinhibition on repossession by the banks on mortgage is alarming. Greece hasn't adopted a homelessness prevention strategy until now. There is no provision of a social benefit. There is no provision of a specific income support program for the homeless people or specific measures for the promotion of their employment. Furthermore, there is no social housing stock in the country, where the only housing association, the Workers' Housing Association, has been abolished last year. The definition of homelessness has recently been legally described on February 2012. The clauses of the law, however, are limited, excluding non-legal residents of the country. Furthermore, the lack of specific policy framework for the issue has made until now the law inactive. Homeless immigrants and refugees face every day the threat of detention and deportation, while there's been an increase on hate speech and attacks against foreigners. I won't continue with the long catalogue of human rights and civil rights violations, because I cannot describe to you extensively even the legal ground that the violations are taking place, because there is no solid legal ground. The catalogue of the social challenges remains long and is constantly expanded. Every new prediction and each new estimation of the inequalities and poverty indicators, whatsoever dramatic, soon enough is surpassed by the new facts. There is a wide and probably growing gap between the scale of the problem we face and the scale of the solutions we offer. However, this evolutionary process may lead to a society of risk, the risk of isolation, exclusion, poverty, unemployment, insecurity. In this light, there is the demand for exceeding the sterile vision of the state as the sole catalyst of social ventures and political actions on the basis of solidarity and human rights. We should also surpass the view that social solidarity means charity and philanthropy. Philanthropy operates exclusively as a relief. Unfortunately, the state also responds on the issue of homelessness and poverty generally, charitably, allocating even the limited funds or the European structural funds on short-term relieving projects and structures. Securing a decent living, social and political participation and collective development, but also conservation and development of the social capital, requires an activating social reaction which will support the building of a social state with a more equal distribution of social goods and opportunities. An indicative facet of this rather idealistic aspiration of a new social dynamic was the homeless march that took place in Athens in April, where homeless people protested peacefully in front of the Greek Parliament, requesting nothing more but a house. Thank you.
Merci.
Thank you. Any comments on that? Who speaks for the third panel now? I didn't see. Right. I'd like to thank you for the invitation and the initiative, and also like to, for the foundation of Abbé Pierre and Emmaus Paris, I'm going to present three. We represent the 300 groups of Emmaus in France, and the Abbé Pierre Foundation is an essential stakeholder in the area of bad housing and creating awareness about the problem. And so we take care of homeless people, day centres, and also general structures for accommodations. So the Emmaus movement, the three structures are basically committed to that poverty is not a crime. It's a context, a very worrying context, which we see the poverty in France. It's a crisis, but it's getting worse and increasing in the number of people out on the street, especially all these issues related to health. A few figures attest this. First of all, the Abbé Pierre Foundation every year issues a report. 10 million French people who are concerned about or affected by poor housing. And the second figure is the people below the poverty line, 2.7 million children affected by this. And the third figure is a situation of homelessness, which is getting worse, because in 10 there's been a 10% increase according to the latest statistics. There'll be 141,500 people without fixed abode, of which 30,000 children. An element that had disappeared in France, which is coming back, which comes back to the appeal of Abbé Pierre in the 50s and the 60s. The slums had disappeared, and we're seeing them appear again. And the 20,000 people we think are affected by that phenomenon. So these figures are very worrying. There is a phone service who people can contact us. It's 115 is the phone. The statistics were done in 37 départements, provinces in July. There was a high rate of non-responses too. So in the face of all these figures, which are very concerning, as I say, there are 2 or 3 other elements which are quite important. It's reflections of a budgetary nature. See, on the political level, camps have been expelled, the Roma camps, and there's a circular that was published in August 2012. It's been applied differently in different places in the country. People have been expelled without any solution for them. The country has recognised the right to accommodation, but there's a circular which has prevented these expulsions, especially people considered priority for housing. But there's a lot of discussion going on around that. So, in the face of these figures, I'm finding the stigmatization is of more and more people, and there's an increasing rejection, anti-begging, anti-sleeping on the street measures, for example. There's the Hungarian example, but the 38 euro fine in France, for example. A big suburb of Paris has done a lot of anti-begging arrests. I live in a town which is just on the edge of Paris. The mayor has issued a decree. You can't prohibiting people looking for rubbish in bins. So. But apart from the position of them, the behaviours that affect people without fixed abode, for example, often people are sleeping in the metro, but there again they're not allowed to lie down on a bench and things like that. And then there are other measures which prevents the installation of people without a fixed abode in the public domain. So, Emmaus Solidarity has its office in the heart of Paris. We've seen that a place just across the road of us, which was got a car park, the co-proprietors have set in an automatic shower system, which triggers off as when anybody stays in there for a few minutes. So, that we're amazed by that. A few years ago, there were also initiative to prevent people occupying these places. So, and then the Poverty is Not a Crime campaign in Europe in June 2012. We wanted to react. We were mobilising both the public in general and mayors to a whole year of exchanges. So the two fronts of the action, if you like, one would be the two foundations within our organisation. So we've had a press conference 11th of April last year to launch the campaign in France in a day centre in Paris. It's really to create awareness and to mobilise people. Where there was a very shocking film. You'll find you'll on the website. It was presented on 11th of April last year, and there are three very strong images in the film. The first message is sleeping on the street, sleeping rough is not a crime. The second one is looking for things in bins is not a crime, and the third is begging is not a crime. In parallel, we've disseminated within the network posters, communications kit, and mainly this is carried out by the provincial organisations of Emmaus France and the ABP Foundation. The website is there to inform, so it's interactive, and you can sign a charter of people in distress, which has been signed by 1,500 people, more or less, which is denouncing criminalizing measures. Anti-non-fixed abode people measures. There's about 20 cases have been highlighted in different areas. So, in France, we're a few months away from the council elections, municipal elections. So, it's a question of working with the mayors. And so the movement has undertaken certain initiatives with the idea of mobilising on the 17th of October. That's going to be the World Day. The mayors there will be involved. At the same time, we're also making an appeal to getting signatures for mayors or candidates to mayor, the post of mayor. I'm going to read very quickly the main elements of the charter. It's a municipal charter of rights for people in distress. So this responds to a whole range of needs of people in distress. Their survival practices are more and more repressed. We affirm that the social deficit depends on more solidarity and no penalisation of the weakest. So therefore it's a question of acknowledging rights to everybody in terms of accommodation, health, hygiene, and the right to protection. And then there's the two main themes on which we demand action to the mayors or candidates to those posts. They recognise the right of people to look for a means of survival. Clothes, a roof. That should never be at the expense of a third party, but it should be recognised. It shouldn't be considered a threat or a nuisance. In the political debate, certain municipalities or towns have stigmatised the often the elected representatives have been stigmatized and been had the finger pointed at them. So, especially with mayors in the large cities or towns or medium-sized, there's a publication of results and set up a sort of tribune to disseminate these results. So, we also need support at European level. It's not a question of hiding social poverty in society. It's not a question of stigmatizing people just because they're in the street or penalizing them. They should be helped and they should be taken into shelters or whatever. Things have changed. And there's a fear on the part of certain mayors to see these new reception centre for homeless people, day centres, but it's worrying to see in terms of the increase of the homeless people, the structures have changed. Well, now we've got a humanization plan, as they call it. It's not a question of dormitories anymore. Often in individual accommodation with people are making an effort to provide accommodation that will facilitate the social reinsertion of these people. So this needs to be worked on with the mayors and, as I say, people candidates to municipal elections. So don't hide it, don't relegate it. The mayors and other posts should take responsibility for the introduction of these measures. So we know to go from a culture of repression to one of integration. Thank you very much.
Merci à vous.
Thank you very much. We're going tight on time for the conclusion after the very diverse and very important examples which give us an idea of the we're sharing in Europe. So, Mrs. Beers, would you do it now?
Yes, thank you very much. First of all, I would like to say that we've heard from experts, legal experts, and also from witnesses that we are facing an already substantial and even more growing problem of criminalization of homeless people. And it's occurring all over the European Union. There is not a good practice, I could almost say, from listening to you all this morning. And even though there is a European legal framework on fundamental rights, we can see that rights of homeless people are treated differently than rights of other people. And having a legal framework to protect the most vulnerable is not the same as accessing and implementing those rights. And interesting things have been said here for action on an EU, on a national level, and on a local level. And these are also the things that we're taking on board as FEANTSA, but also back home in our countries. We've talked, ideas have been raised on the development of indicators on homelessness and the use on a European level, and the use of them in the country-specific recommendations, so that the European Union can actually mention this and steer the member states towards improvement of the situation. There's also been mentioned the possibility of audits in the EU member states on the practice of prevention of homelessness and on accessing social and human fundamental rights. Then on a national level, parliaments need to be made aware of the trend of criminalizing and also the need to secure access to the fundamental rights in all local and national regulations. And the same applies to local authorities who in most of our, or at least in many countries, are responsible for the policies on prevention of homelessness. The awareness raising is very important. Also, to quote Madame Beres, push it on the political agenda, and I am sure that Freek Spinnewijn after me will say something about that for the actions that FEANTSA will be undertaking in the next few years. Because we're talking about years, we're not talking about solving this problem in a very fast and quick way. But to conclude my closing remarks, I would like to thank, on behalf of FEANTSA, Madame Guillaume very much for giving us the opportunity to organize this important hearing today. I would like to thank all the experts and witnesses for their excellent and very worthwhile contributions. And I also wish to thank Samara Jones from the FEANTSA office in particular for the preparation and for the organization of this meeting. So thank you for that. And I will now give the floor to Freek Spinnewijn, the director of FEANTSA, for his final remarks.
Thank you. I should thank you for participating, especially for your for the mentioning the name of the director of the FEANTSA very well.
And the wrong last name for the European cooperation. Okay, two words from my side. I think, first of all, it's not been said here, but we know as FEANTSA, homelessness is on the increase in all EU member states. And in some countries it's a dramatic increase, like we heard from Greece. And in a rapidly growing number of countries, criminalization of homelessness is on the increase as well. And it's not only Hungary, as we have heard, because sometimes we tend to just focus on Hungary. But if we look at the local level, it's happening in a whole range of countries. So we have to be concerned of that. And I think the increase in homelessness and the increase in visible homelessness and the increase of criminalization of homelessness, they probably go together. Why is there an increase in criminalization? I think it's probably, if you put it very simple, two reasons. Sometimes it's based on a vicious political agenda. I mean, people that really want to criminalize homeless people, but I think it's a minority. I think often it is because of total unawareness of what to do about the problem. And I think that brings me to a few suggestions about what the European Union can do, and especially the European Commission. I think, in one word, the European Union can be more proactive on the issue of homelessness. Absolutely more proactive, and certainly the European Commission. First of all, it can be more active in supporting member states to develop the right solutions on homelessness. It can happen through monitoring progress, it can happen through funding research, whatever. There is plenty of possibilities there. We have heard Commission officials referring to the funding that is available at EU level. Yes, there is funding available at EU level, there is the European Social Fund, there is the European Regional Development Fund, but don't make the claim too obvious, because homelessness is not even mentioned in the legal documents underpinning these financial regimes. There is no mention of homelessness in the European Social Fund, and there is no mention of homelessness in the European Regional Development Fund. So, of course, it can be used. There is the possibility, but when I say proactive, I mean proactive at EU level and mention homelessness as an issue of concern. And then there is also legal action. I mean, I think we should not forget that there is potential for legal action. The representative of DG Justice referred to the Anti-Discrimination Directive. Do you know that in Hungary, the people that are criminalized in Hungary, there is a huge overrepresentation of people that are disabled, that have a disability, that are formally recognized as disabled? Is that not some kind of discrimination? Could we not use the anti-discrimination legislation at EU level to address that kind of issue? That's what I mean by proactive. Not wait until there is no other possibility but to do something, but think about how to use the EU actions that are currently in place. And the best way to be proactive is by having an EU strategy on homelessness, which has been asked by the European Parliament twice in the form of a written declaration and in the form of a resolution that was voted about a year ago with 600 MEPs for, which is unanimity in the European Parliament if you take the idiots and, sorry to say it, and the anti-Europeans out of that, it's unanimity from the Conservatives, unanimity from the Socialists, so I think you have a mandate there. And I just want to end with three very concrete proposals. Do something about the European Citizens Initiative. Make sure that in all countries, homeless people, if they have no address or no register, that they can take part in the European Citizens Initiative. We are at the moment in the EU Year of Citizenship. I think it would be a nice sign. There was a Hungarian person that sent a petition to the European Parliament about the situation of homelessness. The Commission was asked to give some input in that and see if something could be done. The reaction of the European Commission was, we cannot do anything because it goes beyond our competences. We have heard from Adrian it's not true. Let's revise that kind of reaction and do something about this request of this Hungarian citizen. And ask the Fundamental Rights Agency to do a research about how to use human rights instruments to combat extreme poverty. It is a request from the European Parliament. I think we should honour that request. So in the longer run there is things to do, and in the short term there is things to do to stop the criminalisation of homelessness. I hope that helps.
Thank you very much. Thank everybody for your participation.